Good morning, friends. I'm going to have today the seventh lecture on law and economics. It is on the limitation of property rights. We have already talked about the importance of uh, importance of right as well as property rights, hence the establishment of right in the previous lecture, and what are the questions normally being asked for effectively having a property right were being discussed. And today, what I'm going to talk about is actually this question, that is, if we lose property, what is going to happen? What are the problem with someone intruding into the rights of somebody, and how we do deal with that? So, first of all, we have a problem which is called the adverse possession problem. Normally, it is called the squatter's right. That means if you occupy someone's property for long enough, you become the legal owner, provided that the occupation was adverse to the owner's interest and the owner did not object or take legal action. So, what is the problem with this particular issue is, well, I mean, the positive side of the same is called clear up uncertainty over time and allow land to be put to use for various good purposes, and whatever the owner wish to. But at the same time, it has the problem that is there is cons. Owners must incur the monitoring cost to protect property. So, being you as the owner, you have to constantly watch the property, and then the watching of that particular property is going to be very huge in that sense. So, this is a problem with the adverse possession, and at the same time you have other problems like when you lose your property, there are laws governing lost and found property. So we call it as estray statutes. So estray statutes is very important in the United States, and also in India we do have similar laws to deal with such problems. So let us talk about property right, that is the necessity of having this private property right, or we call it as private necessity of uh, uh, dealing with the property. So when you have to apply this particular clause, etc., need to be looked into. So property rights generally protected by injunctive relief, as I have said in the earlier lecture, where injunctive relief has always been preferred by the owner. At the same time, it is not the case with the person who is actually got harm, or we say that the person who used the property. So in that particular case, let us discuss a very famous Supreme Court a case. This is actually the case fought between or fought by Plouffe and Putnam in the Supreme Court of Vermont in 1908. What is this case? The case is Plouffe was sailing with his family on Lake Champlain. Then unforeseen storm came up, and Plouffe found out that there is a nearby island which was owned by Putnam. So tied up to pier on owned by Putnam. What happened is that Putnam's employee cut the boat loose. So well, maybe had some harm. So what Plouffe did it, he sued against Putnam. So this is actually the context which we are going to discuss. So in the whole property right literature as well as contract, we use this law, which is very important. In this case, which is very important implications and different legal premises. So court sided with Plouffe. That is the result. So what the court judged as the following: that is, private necessity is an exception to the general rule of trespass. Okay, and in emergency, okay to violate someone else's property rights, still must reimburse them for any damage if you've done, or whatever, if you've done then you must pay the damage. So this is actually the underlying or remarkable observation which was made in 1908 in this case. So that means the property right is no longer in that sense an absolute right, or kind of even somebody recognize also it can be get violated, and if you get violated it will also be rewarded in terms of damage. If that is the case, then it is very clear that it can be unbundled. So as we have pointed that rights are in fact bundles, okay, bundles of what you can do and what you cannot do, etc. So unbundling the right is very important. Therefore property, a bundle of right approach is the most understanding one. And can you unbundle them? This question immediately arises, and separate them, sell some and keep others. So technically speaking, property always comes with a bundle which is inseparable. But there are incidents like we have already seen, and there you can actually use unbundling. So prohibition on perpetuities, for example, is I can't separate the right to own or live on my land from the right to sell it or turn it into golf course, etc. So these are the issues which always comes up. So but in some instances you can unbundle. Okay, so land ownership consisted of three separate pieces. For example, estate, that is the surface estate. Then you have support estates, which is underneath of the surface estate. And then you have mineral estate. So these are actually normally comes under a property. For example, if I am owning a piece of land, all the three comes in. Again, there are other, the biosphere is also there. We'll discuss about that later. So next, two important limitation on property right imposed by government. First may discuss on eminent domain, but for the two are government can limit how you use your property. We call it as regulation. Then government can take your property. We call it as eminent domain. So the regulation and eminent domain is the two mechanisms the government can impose. And this is very important to be noted, because if we talk about the questions of property in India, for instance, the first amendment of constitution itself is based on actually the property right, especially the private property right problem. And the third and subsequent amendments, I think more than a dozen amendments before the repeal of private property as a fundamental right. So all this basically most of this is having something to do with private property and the bundling problem basically. So that is also related to this particular issue, that is whether the government can regulate or whether the eminent domain is actually imposed upon. So these are the questions normally we are going to discuss here. So as I noted, let us first talk about the taking, or we call the eminent domain of this, the power of the land acquisition power, which is vested with the government of India or state government. Now, first of all, let's talk about takings. So, one role of government to provide public good. This is actually widely accepted even in our LRR, that land Rehabilitation Act, that is the recently passed one, where the same is actually been addressed. So, but now who can provide public good and what is public good, etc., can be also defined by the government. So when public goods are privately provided, normally what happens, we have already seen it, that is under supply of resources. For example, defense, roads, infrastructure, public park, art, science, especially in the time of COVID. It is very clear that public health care system is due to the dearth of public health care system, the world is now having a lot of problem. So the importance that is under supply is going to be the problem when public good is being provided by private party. So this is very very important. To do this, government needs land. So in order to build infrastructure or whatever health facility, educational institution, etc., the government definitely need land. So which might already belong to someone else. So in that context, the government has to take it. So this is what has actually happened in the independent India. The first, maybe before the First Amendment, the government of India, the Zamindari, Mahalwari, Raitwari, all kinds of the system, their land system, were being prevailed at that time when the country got independence, a republic. Then the government has to take over certain things for certain purposes, and that's been questioned in the Supreme Court. And in fact, the Supreme Court verdicts came in favor of many of these private landlords. That made the government to take the initiation to immediately repeal the constitution, and the first amendment of the constitution came into 1950 itself. So that is the kind of history normally we do have. So taking is therefore is a very very important one, and most countries government has a right of eminent domain, whether it is in India or in US. Right to seize private property when the owner doesn't want to sell. So this type of seizure also called takings. Okay. So in the US Constitution, Fifth Amendment, nor shall private property be taken for public use without just compensation. This clause is there. And even in our LRR also, this recent Land Acquisition Act, there is also this provision. So in India, the first, fourth, seventh, and 25th Amendments to name the major alterations related to the property preceded the apogee manifest in the 44th Amendment to remove property is fundamental, as I pointed earlier. So even under this, government can only seize private property for public use. Now, this has been now voted down. That was the criticism which was with the 2015 LARR. So I'll come to that later. And only with the just compensation consistently interpreted to mean fair market value. So normally this is what is the explanation given for the just compensation, that is fair market value, what the owner would likely have been able to sell the property for. So but in Indian case, even such a legislation is weak. The LARR 2013 and the subsequent 2015 amendment and recent bill in parliament too weakens the right of the people to get even just compensation. So this is an irony in that context. So therefore taking also has a sort of a negative effect in that sense. So I'll come to that nitty-gritty. So why the question now, let us move to the question that why allow taking. So why these limitations? Why require compensation? Why only for public use? Why not for the private purposes? Because you have already seen the Singur Nandigram firing, land acquisition case and subsequent agitation in problem in these places. In that nano plant has been moved to Gujarat, and now the plant is no more. The plant was shut, no production, nothing. So what does this mean? So the government should only take private property. At the same time, in the nano case, there are a lot of soaps which was being received by this company. That means public money has been given than actually the kind of benefit that which they're supposed to generate in the case. So these are the things which people ask that, why should we give the land to a private person or sort of thing. So The government should only take private property with compensation to provide a public good when transaction was preclude purchase the necessary property through voluntary negotiation. So this is the kind of principle which we were sticking upon from the last lecture onwards. Let us discuss a case regarding one of the oldest case with regard to this thing. So sorry, this is a new recent one, and with regard to this is not that old. So Poletown Neighborhood Council versus Detroit in United States. So 1981, GM was threatened to close Detroit plant. This would cost city 6,000 job, a million in tax revenue. So cities used eminent domain to condemn entire neighborhood. So 1,000 homeowners and 100 businesses forced to sell land, then used for upgrading plant for GM. City claimed employment and tax revenue were public goods, which justify use of eminent domain. So this is a kind of one justification which has been done. Now this is also the same cases now can be seen many parts of this country. We will discuss about this particular problem in the subsequent slides. So for example, in the Michigan Supreme Court, alleviating unemployment and revitalizing the economic base of community, valid public purpose. So the benefit to a private interest is merely incidental. This was the judgment which was being given by this particular court. That means they were being supporting the Porter neighborhood councils. They were not supporting the neighborhood council's plea, but what they have done is actually they had sided with the this particular city office and Detroit plant. But the same was being overturned in 2004, ruling in the case Wine and Hathcock. So we will discuss this in the subsequent thing because this is very important. Similarly, there is another case that is Kelo versus City of New London, 2005 US Supreme Court. So where Posner, the economic analyst, describes that Wizard had decided to build a large research facility next to a 90-acre stretch of downtown and waterfront property in New London. Okay. The city hoped that Wizard presence would attract other business to the neighborhood. The plaintiff owned residential properties located on portion of 90-acre tract. So it might have been impossible to develop those areas had the areas remained spotted with the houses. So the city would solve the problem by condemning the houses. So what they have done is actually simply condemn. It said the area was sufficiently distressed to justify a program of economic rejuvenation. This was the kind of logic which was being given. And attorney argued the case, and if jobs and taxes can be justification for taking someone's home or business, then no property in America is safe. So this is a very classic argument which was placed by the attorney against this particular ruling. So if we are talking about jobs, taxes, etc. are the basis of life, then nobody can own anything in this country or any other country. So there are problems, and in the Indian context I've already the land grab of West Bengal government for nano plant and followed protest of the people led losing many lives and livelihood. So the invitation of the Gujarat government to Tata nano plant and subsequent 30,000 crore subsidy swaps, which include hundreds of acres of private and public land at a cheap rate. So these are actually numbers which was howling around, or it is being circulated in the newspaper and all. So the question is that can we argue the above case justifies the public use clause of taking or the eminent domain under a just compensation principle? This is a very important question normally uh, we need to ask, and we'll come to this question a little later. So let me first then go to the first problem, that is the regulation. So multiple form of public ownership is there. As we had already discussed, open access, anyone free to use the resource leads to overutilization. This is problem with the overutilization of a public property, or open access property. Example, oyster beds, fishery, etc. Now, in the unanimous consent case, that is opposite of open access, that is multiple owner must or agree to any use of the resource, leads to underutilization. This is what is called the unanimous consent. So example, empty storefront in post-communist Moscow, which was being presented in the Heller's paper, which we had referred in the last lecture, where Heller found out that storefronts are vacant, but other the the streets are basically filled with things. This is the same thing happened in Poland also. So anti-common is the result. That is, we have already seen that the underutilization leads to an anti-common problem. So anti-common caused by existing intellectual property right, for example, is also very important, because if you have too much right, then you cannot develop a drug, you cannot actually move to a different understanding, because there are too many consent you have to make, and there is not only too many consent but unanimity in that too many consent, which is in fact technically as well as in the real world very difficult to achieve. So there comes another set of problem, which is called the political control regulation. So this is actually the context where we introduce this problem of regulation. So open access, unanimous consent, these two things are very difficult. So what you propose, a control, which is called the regulatory framework. So dividing the mountain pasture among individual owners would require fencing it, which is prohibitively expensive. So therefore you have to have a regulatory understanding. Instead, what they do, the highland pasture is held in common, with each village owning different pastures that are separated by natural features such as lakes and mountain peaks, etc. So this is the way which normal people try to regulate the use of the thing. And if each person in the village could place as many sheep as he or she wanted in the common pasture, the meadows might be destroyed and eroded by overuse. In fact, the common pastures in the mountains of Iceland have not been overused and destroyed because the village have effective system of governance. So this was we discussed in many paper, and they have adopted rules to protect and preserve the common pastures. In the Eleanor Ostroms and many other people who had worked on this common property problem, they were all had this kind of conclusion. That is, sheep are grazed in common pasture in the mountains during the summer, and then returned to individual farms in the valley during the winter. So the total number of sheep allowed in the mountain pasture during the summer is adjusted to carrying capacity. So each member of the village receives a share of the total in proportion to the mountains of the farmland where he or she raises hay to feed the sheep in the winter. So this is how people try to manage themselves. So in that context, let us also go to the legal case and see that how regulation plays a role. In 1800, PA Cole purchased mineral and support estate, that is Mahone owned surface. So this is the case. In 1921 Kohler Act prohibited mining of anthracite coal in such a way as to cause the subsistence of, among other things, any structure used as been passed in 1921. So PA called sued government claiming the regulation was same as seizure their land without compensation. So this is a kind of, so you introduce a new law which is ultimately seizes your action. So this is what is called a seizure of somebody's action. So this is why this particular company had, that is PA called, had sued. While property may be regulated to a certain extent, if regulation goes too far, it will be recognized as taking. So this is kind. Now you should understand the difference between a regulation and a taking. So regulation cannot be actually regulating in such a way that it acts as taking. So that is why this particular example of Pennsylvania Code versus Mahone is important, as well as this PA Code suit against the government uh, of introducing this particular law. And most of the time, when you introduce a new regulation, you should also ensure that that is not going to actually curtail the entirety. This is true with many of the recent discussions in the Indian context, especially these questions of NRC, questions, so many problem it creates because regulation. This is actually maybe having a good intention of regulation, but the problem is that it is act as a seizure or displacing people forever for without because of not their sin but somebody else. So these are the problem which we have to really talk about. So Bloom and Rubenfield example is going to be Bloom and Rubenfield in their compensation for taking an economic analysis paper discuss such problems very extensively. Let us discuss about that. Support compensation for regulatory taking. So they were talking about a support compensation for regulatory takings, where shifting burden of regulation from owners of affected property to all taxpayers, equivalent to selling everyone insurance against harmful regulation. If such insurance were available, people would buy it, but it is not available for a usual reason. Insurance market may fail because of the adverse selection and moral hazard. So government should provide it instead by paying compensation for regulatory takings. This is what is their standard understanding in this particular case. Where they also this in this case there is another set of problem where it is not actually regulation, it is a kind of zone where also people try to restrict the property usage like unbundling, they are unbundling and making zoning laws were being introduced, and it is also a practice these days, and now increasingly people are asking for. Now, zoning laws distinguishes industrial area from residential area. This is one of the very important aspect. Then Nolan versus California Coast Community case is a very interesting case where this can be understood. Nolan owned coastal property, for example, asked for permit to expand building, which would diminish view. That is, commission donate a public walking path and you get permit. This is what is the commission saying. Now, Supreme Court said such a deal only legal if there is a clear connection in excess between the harm being done and the remedy. So this is very important. When you make zoning, you also be very careful. So as we came across the problem of dealing with the issue of taking and issue of regulation and issue of zoning, if we won't be carefully analyze these rules which is normally introduces to deal with the property, it can go whatever extent it can. So that is a problem with it. So do we think that we have sufficient zoning laws in India? In India, we don't have much. With this, I would end this lecture, and we will come to the other part of the story. in the subsequent lecture. So thanks for listening, and I hope you enjoyed the lecture. So thanks once again. Let's break for the day.